international law until 1990, when all three Baltic states declared their independence. In the 1990 Restoration of Independence Declaration, the legislative body elected in partially free elections, because the Soviet army was still stationed in Latvia, declared that the Satversme is in force, but ought to be suspended now, except for those articles which only popular referendum could suspend. In other words, the point of departure was clear at that moment. Latvia had a constitution derived from Grundnorm. It was necessary to see whether it was capable of adapting to the changed circumstances after 50 years of sleep. Following the analysis and free elections in 1993, the Satversme was re-effected fully, and it has seen only some amendments, but the institutional system and the division of powers has remained the same as originally conceived. One of the general principles of great importance for Latvia, and one that delimits Latvia's modern constitutional identity, is the principle of state continuity. It is important to point out that the Latvian constitutional law recognizes the concept of constitutional identity, which means the core of the constitution. And I shall come back to this concept a little later. The principle of state continuity derives from the Grundnorm in the circumstances when Latvian people could reclaim independence of their state in face of a long unlawful occupation. It is intertwined with important rules of international law that began to emerge between the two world wars. The principle instructs the content of Article 2 of the Satversme, which contains the principle of popular sovereignty. The 4 May 1990 Declaration on the Restoration of Independence is based on the principle of state continuity. The principle of state continuity also requires all Latvian constitutional organs and executive bodies to comply with this principle in carrying out their public authority. This principle instructs Latvia's foreign policy and is the basis for the formulation of various international claims. Latvia insisted that it is not a new state successor to the former USSR. Instead, it continues its proper legal personality and rights and obligations along with. Latvian constitutional doctrine therefore argues that the restoration of independence deriving from the principle of state continuity put forward specific requirements as concerns the legal basis of Latvia in 1990, namely the restoration of the 1922 Constitution. The principle of state continuity obliged Latvia to re-effect the 1922 Constitution, at least within such a scope that comprised the principles and norms describing the constitutional identity of the state founded in 1918. The principle of state continuity has come up in several cases in the Constitutional Court. The court had to identify both the scope of the principle and its practical implications. One could attempt to provide a typology of cases where the principle of state continuity has instructed the application of the Constitution. First, there are cases which are about the restoration of the identical Republic of Latvia following the long illegal occupation. In other words, these are the cases where the court had to explore the content and limits of the sameness of the state after 1990, following several decades of only de jure existence and a very limited de facto exercise of state power. I should add here that from the perspective of the constitutional identity of Latvia, the relationship between the content and limits of sameness has not yet been fully explored doctrinally or in the case law of the Constitutional Court. We are awaiting new cases and possibilities. Second, these are cases about the changes that have been inflicted on Latvia during the illegal occupation, namely consequences of illegal occupation and their constitutionality. Just some examples of the case law in the so-called double citizenship case, which belongs to the first category of cases I just mentioned. The court concluded that the doctrine of state continuity comprises also the principle of continuity of citizenship. If the state chooses to be based upon its continuity, then the regulation on citizenship should comply with this principle. The principle of continuity of citizenship envisages an obligation of the state to the extent possible to restore the status of and the rights pertaining to citizens who were citizens prior to illegal occupation and their descendants. However, the court also decided that even in the context of the principle of continuity, the state does not have the obligation to register as citizens all persons who were citizens of this state before the loss of independence. The court insisted that the persons concerned had to voice their interest in that their citizenship rights would be re-effected. In other words, the court upheld the presumption of citizenship, but considered that it was a rebuttable presumption. In other words, for the purposes of establishing sameness of the state, it was the presumption that was important, but not the exact numbers of citizens. The Constitutional Law Commission, which existed in Latvia between 2008 and 2013, a think tank established by the President of the state, found that the people of Latvia form the core of the Constitution. Namely, it's an element of the constitutional identity. The people of Latvia are defined on the basis of citizenship. The Commission said, naturally, the body of citizens is subject to change and evolution, but such a change should not affect the Latvian nation, which is the core of the body of citizens. Another leading case, a controversial case, concerned the border delimitation between Latvia and the Russian Federation, in which the court was asked to assess the constitutionality of the draft border agreement between Latvia and the Russian Federation. The court referred in detail to the notion of state continuity in situations where a state is deprived of its independence in violation of international law. The court noted that many states did not recognize that the Baltic states had become part of the USSR. It means that the state de jure existed. This is, in essence, the doctrine of state continuity in international law that follows from the prohibition of use of force or threat of use of force. In this case, however, the court decided that Article 3 of the Constitution, which sets forth the territory and the state boundaries, provides for a core of a territory which cannot be lost if the state identity is to be preserved on the one hand, and on the other hand, there are acquired territories that do not form part of the core. The territory that was subject to a dispute with Russia is situated, the court said, on the margins of Article 3. In the court's opinion, if the state decided to give this territory up, it would not violate the core of Article 3. The judgment received very vivid debate in legal doctrine. The court found that in view of the principle of state continuity, it is not necessary for the state to restore its independence in exactly the same territory with the same citizens and the same constitutional order as it was before the illegal termination of the state. It is necessary to accept that in the course of time, the body of residents of a state will have changed and the territory and constitutional order may also change. The doctrine of continuity accepts such a change, but in such circumstances, in restoring the independence of the state, the sovereign must act in accordance with the doctrine of continuity and accept changes not in accordance with the tabula rasa principle, but on the basis of the previous constitutional regulation. I should say that the court in this case was more guided by the theory of state continuity in international law, which indeed accepts that the territory, people, and even government may change, but it doesn't necessarily affect the existence of a state as the same legal person in international law. In terms of the constitutional law, it is important to add that the constitutional identity has to be maintained to claim the same state. The constitutional identity, in my view, is a stricter test and may require to restore the same borders or the same principles of citizenship. This is to be determined by reference to the Constitution itself and its drafting history. As I mentioned, the Court has not yet fully explored the scope of the interaction between the principle of state continuity as part of the basic norm and the essential elements or core of the constitutional identity. It has recognized the two principles, but has been rather more careful in determining their scope and in using the stricter constitutionality test. A very comprehensible study, I could mention the following cases: calculation of old age pensions for citizens and non-citizens, where they have both worked outside the territory of Latvia and contributed to the budget of the Soviet republics other than Latvia. Also, more recent cases should be mentioned. One concerns Soviet military pensioners who desire to receive both the Russian military pension and the Latvian old age pension from the Latvian authorities. The second case concerned the use of the Soviet normative acts in determining the age of early retirement of the parents taking care of their children with disability, when Soviet acts had provided for the recognition of disabilities of children on a very limited scale at that time, or not at all. The Court found that the principle of continuity means that Latvia was not the successor to the rights and obligations of the former USSR, and that Latvia did not have to undertake the commitments of another state to provide old age pensions to non-citizens for the period they had worked and contributed outside the territory of Latvia. On this issue, there is, however, a disagreement between the Constitutional Court of the Republic of Latvia and the European Court of Human Rights. By all means, these are complex cases, because on the one hand, Latvia did not inherit the responsibility for changes in its territory during the Soviet occupation, and on the other hand, it has declared that the principle of state continuity ought to be applied in harmony with the principle of respect for human rights. A few more explanations on the principle of direct effect and primacy of binding international law in the Latvian legal system should be provided. Already in 2002, in the so-called KGB case, the Constitutional Court defined its approach to the interpretation of the Satversme in conjunction with norms of international human rights law and to the use of case law of the European Court of Human Rights. The Court held that Article 89 of the Constitution shows that the legislator did not have the aim to contrast the provisions of human rights included in the Constitution against the international norms of human rights, but quite to the contrary, to attain harmony between them. International law and practice may serve as means for establishing the content of legal norms and principles comprised in the Constitution. The Constitutional Court has underscored that the state may not contrast its national law with international obligations, but it has also very clearly stated that Latvian constitutional standard of protection of human rights can be higher, and in such a case, it is the higher standard of protection that the Court will apply in the specific case. I note here in passing that in principle, this approach should not generate any difficulties in relation to the European Convention by virtue of Article 53 of the Convention. However, in view of the interpretation of the principles of the EU law as provided by the Court of Justice in the Advisory Opinion 213, and in particular the mutual trust principle, as for example applied in the case like Meloni, which would consider that different constitutional standards in two EU member states are contrary to the unity and privacy of the EU law, that may indicate some difficulties. Now coming to the European Union. The Court identified the principle of the core of the Constitution in the Lisbon Treaty case of 2008. And the court said as follows, you have it on the screen: by ratification of the Treaty of Latvia's accession to the European Union law became an integral part of the Latvian law. Thus, to prevent possible contradiction between the Latvian and the EU law in applying national legal acts, the EU legal acts and their interpretation as consolidated by the Court of Justice must be taken into consideration. At the same time, the Constitutional Court also noted that the EU legal acts should be taken into consideration both in applying and interpreting national legal acts and in preventing possible contradictions between the Latvian and the EU law, to the extent that this does not affect fundamental values of the Satversme. The Lisbon Treaty case defines these fundamental values as follows. Consequently, delegation of competences cannot violate the basis of an independent, sovereign, and democratic republic based on human rights and the rule of law. Likewise, it cannot affect the right of citizens to decide upon the issues that are essential in a democratic state. For the moment, this is a rather broad definition of the scope of the core of the Constitution or the constitutional identity of Latvia. The court will most likely be faced with cases in which it will have to work on detail. Nevertheless, it is this position of the constitutional courts that needs to be examined so as to understand the court's conception of state sovereignty and the relationship between the international and the national legal orders. In view of the above, the case law of the Constitutional Court and the legal science in Latvia recognize that the Satversme contains a core which is the constitutional and international identity of Latvia that differentiates Latvia from the other states. International law and the EU law is applied in harmony with and as far as they do not conflict with the core of the Constitution. We have seen that the two principles mentioned above of state continuity and direct application of international and European law both characterize Latvian constitutionalism. But these principles are different in nature. State continuity explains an aspect of the basic norm. Latvia is an independent state which has never ceased to exist. The principle of direct application of international law characterizes the legal system of Latvia that emanates from the basic norm. It is a legal system that is very open to European and international best practices. At the same time, there is a limit to the latter principle because the openness cannot undermine the constitutional identity of Latvia. An example of such a core constitutional value will be the Latvian language as the only state language. It is therefore that a certain hierarchy of principles emerges. The general principles which reflect the core constitutional values of Latvia will prevail over other general principles. To continue with the membership of Latvia in the European Union, the Constitution has been amended twice due to Latvia's membership in the European Union. Just to remind you, the basis for the membership was included into the Constitution on 8 May 2003. Latvia joined the European Union on 1 September 2004. After long debates, the opinion prevailed that only Article 68, which belongs to the Charter on Legislation and provides for the procedure for accepting international agreements by the Saeima, has to be amended. 3 new parts were added in this article, which you see in front of you. The second part is the interesting one. Upon entering into international agreements, Latvia, with the purpose of strengthening democracy, may delegate a part of its state institution competences to international institutions. Also, Article 79 concerning national referenda was amended to delimit the scope of national referenda on the membership in the European Union. the important part, a draft law decision regarding membership of Latvia in the European Union or substantial changes in the terms regarding such membership submitted for national referendum shall be deemed adopted if the number of voters is at least half of the number of electors as participated in the previous Saeima elections. Now, the referenda that took place on 30 September 2003 took place in accordance with the provisions of Article 68, Part 3, and the requirements of Article 79, Part 2 of the Satversme. In view of the amendments of the Constitution as presented to you, the Latvian legal science and the case law of the Constitutional Court do not recognize that with the membership in the EU, Latvia's sovereignty has in any manner been affected or diminished. Even though in the constitutional debate, which took place for several years before the accession to the EU, there were proposals made by scholars that Article 2, which provides that sovereignty in Latvia lies with the people, should be amended to reflect the membership in the EU. That proposal was rejected. In the light of the choice made, it is indeed correct to say that in Latvia, the constitutional law and doctrine do not recognize any limitations on sovereignty, and the Constitutional Court has, in fact, amplified that by saying, in assuming international obligations or in the procedure of acceding to a supranational institution, sovereignty is seen rather as exercising the sovereign rights than their restriction. And you see the rest of the Constitutional Court's analysis. Thus, the reconceptualization of the concept of sovereignty, if it is on the agenda at all, has not been a popular topic in Latvia. The concept of sovereignty always has been linked to the exercise of power in internal and external relations, and this exercising has always been subject to the sovereign power, the people. In the case law of the court, the concept of sovereignty is linked to the right of the totality of the state citizens to decide on issues that are essential in the life of the state or society. In the meaning of Article 2, the concept sovereignty comprises not only the right to final say, but also the obligation to examine the operational conditions of international organizations as such. And also in this context, the right to the first say is important. A few more observations. First, the court takes the position that an independent and sovereign state in its core cannot be divided, pooled, or shared. This means that for the moment, Latvia does not envisage the European Union as anything other than an organization based on the consent of states expressed in a treaty. Second, the court also stands by important values that ought to characterize the legal order: democracy, rule of law, and human rights. In fact, the main amendment to the Constitution, as you have seen, that Latvia made upon accession to the EU was the condition that it transfers some of its competences to the international institutions with the aim to strengthen democracy. In other words, this is an example where a state evidently guards the supremacy of its national legal order, and where national legal order has a number of qualitative requirements with respect to the international legal order. Now, the text of the Satversme does not directly indicate that the Constitution has a higher legal force vis-à-vis any other legislative acts. At the same time, the force of the Satversme as the supreme legislative act has always been taken for granted. Until now, it has not been really explained how this concept of sovereignty is compatible with the openness to international law and the membership not only in the EU, but also, for example, in the United Nations with its Chapter 7 resolutions passed by the Security Council. Latvian constitutional practice and doctrine reflects a mix of absolutist and Kelsenian concepts of sovereignty. The doctrine and the Constitutional Court have entered into the paradox of state sovereignty by accepting that it both demands the power to enter into treaties and rules out the binding force of treaties, which approach, as some argue, makes either sovereignty or international law impossible. At the roots of this constitutional dilemma is the position that sovereignty cannot be restricted and that internal and external sovereignty are part of the same whole. This actually is the absolutist conception of sovereignty, whose presence in the Latvian context is probably not surprising. However, the principle of openness to international law and acceptance of the primacy of EU law makes me think about the Kelsenian monist constitutionalist approach, as I have mentioned at the beginning. Well, also the German Constitutional Court, as you all know, in its case law, notably in the Lisbon Treaty case of 2009, maintains, in my view, a classical position on sovereignty. In essence, the court agrees that the basic law authorizes the legislator to a far-reaching transfer of sovereign rights to the European Union, but such an authorization is conditional on, among other things, the respect for constitutional identity as a member state. In a German constitutional law, you talk about transfer of some sovereign rights and of integration-friendly and international law-oriented stance. Even between our two positions, I see certain nuances. I'm doubtful that Latvia would even accept to talk about the transfer of sovereign rights, which choice is closer to the French constitutional doctrine. All in all, it is the constitutional order of a sovereign state which is the highest underived legal authority above which there can be no higher authority that is its source of validity. It is only pouvoir constituant, the people which decides on new constitutional competences without restraint. The fact remains that, on the other hand, no one doubts today the normative and valid character of international law and the EU legal orders, even if they do not derive from Grundnorm and there is no single sovereign power. The fact also remains that international law is able to accept the validity and equality of all sovereign legal orders. Despite the valid theory and constitutional order of a sovereign state as the highest underived legal authority above which there can be no higher authority, along with the other constitutional orders, along with the constitutional order, the other legal orders exist with relevant mechanisms and principles on the basis of which legal norms are adopted that bind the subjects of these constitutional legal orders. As one commentator on the UN Charter system put it, for example, the erection of the UN Charter system and its subsequent development amounts to a construction of an autonomous, global, increasingly integrated legal order of constitutional quality, claiming supremacy that has profoundly modified state sovereignty. It is not only the UN Charter regime, but other legal regimes based in international legal system, including the EU legal order, that have put forward claims to a certain constitutional quality. According to Kelsen and other legal theorists, this cannot be compatible with the sovereignty of states. There are examples, Latvia included, that show that indeed the common constitutional approach in Europe maintains that sovereignty cannot be divided, certainly in Central and Eastern Europe, and moreover, there is a core of the constitution which cannot be transferred or otherwise affected. The concept in between, the concept of constitutional identity raises a question as to its relationship with sovereignty. In the Latvian constitutional doctrine, the constitutional identity, the meaning of the constitutional identity is in the prohibition to the legislator to change that constitutional identity. Independence, democracy, and rule of law belong to the core of the Constitution. It is therefore that Article 68 of the Constitution provides for transfer of some competences to international institutions only. In other words, the state cannot use its sovereign powers to derogate from the core constitutional values. So the concept of constitutional identity both overlaps but is also a broader concept than the principle of sovereignty. Sovereignty in the sense of independence and popular will be just one element of the constitutional identity. All these legal constructs have not, as I said, as such, impeded the process of building the EU or other international legal orders. It is only when one or the other stretches too far into the sphere of the application of the other that difficulties may arise and have arisen. Here it is appropriate to bring in the Gauweiler case of the European Court of Justice. The Advocate General in Gauweiler case commented on the concept or idea of constitutional identity in the national legal system. That opinion is of particular interest for our debate on constitutional identity and sovereignty. Just to recall you what the Advocate General said. The first is that it seems to me an all but impossible task to preserve this union, as we know it today, if it is to be made subject to an absolute reservation, ill-defined and virtually at the discretion of each of the member states, which takes the form of a category described as constitutional identity. That is particularly the case if that constitutional identity is stated to be different from the national identity referred in Article 4, Paragraph 2 of the Treaty on European Union. Such a reservation of identity independently formed and interpreted by competent, often judicial, bodies of the member states would very probably leave the EU legal order in a subordinate position, at least in qualitative terms. Article 4, Paragraph 2 of the Treaty on European Union comprises the provision that the Union shall respect the national identity of the member states inherent in their fundamental structures, political and constitutional, inclusive of regional and local self-governments. There have been a lot of debate on the meaning of this concept in the Treaty of European Union. The first issue with respect to which no consensus has been reached is whether the national identity of member states is the same thing as the constitutional identity. Some authors believe that the national identity should not be regarded as anything beyond the instantiations of basic moral principles that require a multinational political community to show respect for the identity of its constituent national groups. However, the majority of commentators hold that it is complicated or even impossible to differentiate between the two concepts of national identity and constitutional identity. Neither has the Court of Justice nor the Advocates General provided a precise definition of the national identity. It's been applied on case-by-case basis. At the national level, as already pointed out, in respect of Latvia, the constitutional identity is defined in different ways, which is understandable because the constitutional frameworks differ. You have a definition provided by the Polish Constitutional Tribunal in its Lisbon Treaty. You have a definition provided by the German Constitutional in its Lisbon Treaty case. And the Conseil Constitutionnel, in turn, has noted that the constitutional identity of France is something that it does not share with other countries and is special only for France. Some commentators have said that this clause in Article 4, Paragraph 2 is the legal nuclear weapon. And it is therefore particularly important to establish who controls the launching device of this weapon. As far as the views on constitutional identity are concerned in the Advocate General's opinion in the Gauweiler case, what we actually see is his concern about the hierarchy of legal orders. If the constitutional identity is left exclusively within the competence of constitutional courts, this may undermine the priority of the EU legal order. Having just referred to the views expressed in the doctrine with regards to the potential juridical power of the national identity clause or the concept of constitutional identity, it is evident that the supremacy of the legal order as the key to the classical sovereignty concept is indeed in the center of international national tension. It is obvious that we need to address this dilemma so that in terms of a legal and political thought, we could move forward. You will remember that Advocate General in the Goweiler case formulated the sovereignty dilemma in the context of the procedural dialogue between the Court of Justice and the German Constitutional Court. And he formulated it as follows: therein lies all ambiguity with which the Court of Justice is faced in this reference for a preliminary ruling. There is a national constitutional court which on the one hand ultimately accepts its position as a court of last instance for the purposes of Article 267, and does so on the expression of a special cooperative relationship, but which on the other hand wishes, as it makes clear, to bring a matter before the Court of Justice without relinquishing its own ultimate responsibility to state what the law is with regard to the constitutional conditions and limits of European integration so far as its own state is concerned. The question is whether a constitutional court in an EU member state should not have an ultimate responsibility for the constitutional identity of the state concerned. Or, I would like to ask, whether we should have such a question at all, since the answer in the world still run by states will by definition be a confrontational one. The Advocate General provided an answer, or certainly gave his vision of the order of these competing claims. Further, in his opinion, he refers to the principle of sincere cooperation in Article 4, paragraph 3 of the Treaty on Union, which in the Latvian legal order is very much reciprocated through the principles of openness to international law and direct application and effect of EU law. But these principles evidently do not per se address the question of supremacy. We are in a situation of EU legal order claiming primacy over national legal orders, and national legal orders protecting themselves through a more often use of the concept of constitutional identity. In response to that, the Advocate General introduces cautiously a notion of common constitutional culture of the EU, which is constructed on the basis of constitutional traditions common to the member states. Specifically, the Court of Justice has given preference to those constitutional traditions when establishing a particular culture of rights, namely that of the Union. The Union has thus acquired the character not just of a community governed by the rule of law, but also of a community with a constitutional culture, he says. That common constitutional culture can be seen as part of the common identity of the Union, with the important consequences, to my mind, he says, that the constitutional identity of each member state, which of course is specific to the extent necessary, cannot be regarded, to state matters cautiously, as light years away from that common constitutional culture. Certainly, our poet Rainis, whom I referred to at the beginning, agreed with the idea of common constitutional culture. But it does not answer the question, especially the ones that I have put, especially where one still maintains the hierarchical outlook on these issues. It is to be noted that the space given to the constitutional identity of states in the passages that I quoted is the extent necessary, with the aim that sooner or later the constitutional identities of the EU and the member states will converge. However, the questions remain: who will determine the extent necessary, as well as who will determine the convergence of constitutional identities? It is obvious that each court protects the legal order or legal regime that it is mandated to protect and develop. And I could add an example from the case law of the European Court of Human Rights in the Sejdic and Finci versus Bosnia and Herzegovina case, which was about the constitutional structure, the House of Peoples and the Presidency of Bosnia and Herzegovina, put in place by the Dayton Peace Agreement to stop the atrocities. The applicants were Roma and Jewish origin, and they could only stand for elections if they belonged to constituent peoples. The court considered that to be a discrimination based on Protocol 12 and Article 14 in conjunction with Article 3 of Protocol 1, and the judgment received an undivided acclamation by human rights groups. It has not yet been executed. I think the true nature of the difficult task in front of the other European court was aptly described in a dissenting opinion of Judge Bonello. And he said, these two cases may appear to be the simplest the court had had to deal with to date, but they may well be concurrently among the more insidious. Only the action of that filigree construction extinguished the inferno that had been Bosnia and Herzegovina. It may not be perfect architecture, but it was the only one that induced the contenders to substitute dialogue for dynamite. It is true that the Strasbourg Court mandate concerns the rights of individuals set forth in the Convention. The issue of constitutional structure of the state or its constitutional identity normally do not come up, do not trump individual human rights. But it may happen, and the Strasbourg Court is not too unfamiliar with such situations. In another case, SIS against France, with regards to prohibition of wearing niqab and burqa in public, the court ruled that the prohibition did not violate the Convention and recognized the fundamental nature of the French principle vivre ensemble that belongs to the constitutional identity of France. To sum it all up, the legal landscape is rather saturated, with many actors pulling sovereignty, supremacy, and influence in all directions. We continue to live in the world of states based on an outdated concept of state sovereignty for this legal landscape. What's the way forward? Today, that is the question, as we know, debated in European political fora, and we as lawyers and judges should clearly anticipate in the world of legal thought some of that debate and the outcome. Based on my practice, I would say that after all these decades of development of international and European law, it is still striking how relatively small the presence of international there is at the national level. On the other hand, how relatively insensible towards the national is European and international level. And it is this that is crux of the matter. I would like to repeat Professor Neil McCormick's very pointed invitation at some point in time. And he said, one thing which it is necessary for jurisprudence or the philosophy of law to do in the present state of affairs is to guard against taking a narrow, one state or union-only perspective, a monocular view of these things. The difficulty about sovereignty theory is that it seems to point inevitably in that direction. For the constitutional courts, It is important to begin to accept not the hierarchical meaning of sovereignty, but rather heterarchical and horizontal one. At the same time, the European Court should not run ahead of social and political discourse. I note that the concept of constitutional identity has indeed recently regained in strength, which is a sign of some insecurity too. In Europe, the differences in constitutional traditions have always been important, and one cannot do away with them by an order. Nevertheless, the future of the legal and political thought should move away from the supremacy of legal order discourse and situate itself within the framework of global or universal legal order, which is formed of national and international legal orders on equal basis. It is in fact constitutional courts which stand at the gates between the international and the national. A workable conception of interaction and mutual application of constitutions and international and European law, namely of sovereignty, is within the hands of constitutional courts, with the support of European courts. For building a common European and international space of shared values and common legal principles, I believe comparative law method becomes of central importance and a genuine interest to get inspiration from the neighboring legal orders. I have been inspired by the theory of constitutional pluralism in my talk and in my work. In conclusion, let me recall the view that belongs to the constitutional pluralist discourse, that what is required in acknowledging and handling competing claims to authority coming from national and supranational constitutional sides is an ethic of political responsibility premised on mutual recognition and respect. It is with this understanding that all forms of dialogue among courts that have emerged over the last 15 years are of crucial importance, and more effort should go into making that dialogue genuine and all-embracing. As for European courts, they should understand that there is a limit to the principles of openness to international law, direct application, direct effect and priority and primacy, and the name of that limit is the old sovereignty paradox. The way forward is to reconceptualize the discourse and to move away from competing authority claims towards accepting that all legal orders form a universal legal order, and that we are all national, European, and international actors responsible for shaping it. That, for the moment, requires to accept the proper roles that each court has, be it constitutional and European. It also requires to leave behind one state or one court, one union view, and to move towards the common goal that I hope we share, that is global legal order premised on the principle of rule of law. And I share you for your attention. Thank you very much.
So thank you very much for your most insightful speech, which gave us insights in a, let's say, world of legal thinking some of us never come across to. Not Kelsen, not the basic subjects, that would be outrageous, but the particular Latvian perspective is perhaps unknown to many of us. So I open the floor for questions from the audience.
Hello. Yeah, thank you very much, first of all. I do have one different perspective to add, probably, because this discussion about European identity, or the constitutional identity, was very, very prominent, especially in Germany in the last couple of years. For example, after the 2009 judgment of the Constitutional Court. But I wonder, especially if we look at the situation we have in Poland and Hungary today, why is no one talking about a identity that might be enshrined in the European treaties? Because we always understand constitutional identity as a concept somehow protecting national, somehow safeguarding national constitutions from something that might be outrageously or somehow intruding from Brussels or Luxembourg. But why couldn't we turn it around and see like the constitutional courts of the member states and the European Court of Justice as working together as somehow in conjunction to shape out and rephrase a European identity that's not only enshrined in the constitutions of the member states, but also in the European Constitution or in the European treaties. Thank you.
Yeah, thank you for the question. I think we are probably speaking in the same direction. The last part of my speech, if we accept that, in fact, we are already living in a world of global legal order, and certainly in Europe it's even more prominent, then the only way forward is not to just sort of isolate, which is a current process, of course, one another, but to sort of agree that we can build further the European legal space together. But that, as I said, that requires a certain culture of mutual respect. And I think that's where I put it. So we really need to talk about a culture of respect towards each other. And it is when that will be achieved that we will move forward, sort of in more qualitative terms. Yeah. So this debate, for example, today is extremely important because you are learning about Latvia a lot. We follow German jurisprudence a lot, I can tell you that, in Latvian Constitutional Court for obvious historical reasons, since the roots of our constitution are actually here. So, but it has to be a two-way street or you know, many, many streets back and forth.
Frau Burcher?
Yeah, thank you. I've got a comment and a couple of questions. Yeah, first, thank you for your very fascinating talk. I really enjoyed it a lot and I learned a lot as well. So first, the comment, I really agree with your, normatively at least, with your constitutional pluralism approach, which is also my approach. And I'm very happy to see that this approach is really it's coming from someone who's, you know, is the head of a constitutional court. That's not that often that you can hear this. But at the same time, I'm wondering whether maybe it's a little bit too idealistic to really expect this to happen right now in this time, you know, at the moment, and what do you think about that? Do you really see chances of this constitutional pluralist approach to be really implemented into the jurisprudence both of the constitutional courts within Europe, but also within the jurisprudence of the European Court of Justice? It's a, as you say, it's a two-way street, so both have to implement this and recognize that primacy is not, you know, it's not just, as you said, just a question of primacy, because that obviously creates a conflict, but that there might be both hierarchical and hierarchical elements in the construction of a European constitutional law that might coexist and that have to coexist together and be brought into some sort of system through the jurisprudence of the courts. So that was my first point. The second set of questions is related to constitutional identity, and here two short questions. The first one is whether you, from the Latvian perspective, also see the risk that you already mentioned in your first comment, the risk that constitutional identity is used as or misused as a mechanism for populism by different actors in different member states of the EU. Do you see this risk for the Latvian constitutional order as well? And then related to this is the question, what is actually in Latvia the procedural framework for constitutional identity within the you know, how can actors in society, or if at all, can they go before the Constitutional Court and really claim that in a specific circumstance it's a violation of constitutional identity, other than just, you know, the accession of the state to the EU, but like as we have with the constitutional review in Germany, is there something comparable or different in the constitutional law of Latvia? And then my last question relates to the self-understanding of the Latvian Constitutional Court, I would say, with regard to the development of the jurisprudence of both supranational and international courts in the last few years, where you could probably claim that for example, the European Court of Justice has been noticed to take a step back, to, you know, back off a little with regard to the claims of the constitutional courts. For example, recently, last year in the Tarico case, the Italian case, we're now in the, you know, second round of this procedure. As you know, the court now actually went very far in recognizing the arguments of the domestic court and didn't let happen what happened in the Danish situation, for example, when then there was, you know, the situation where the domestic court would not apply the judgment of the European Court of Justice. So with regard to developments like this, do you see that the role of the domestic constitutional courts and especially of the Latvian Constitutional Court is really strengthened? And if so, with regard to the international and supranational level, and if so, do you see this as maybe a hindrance of implementing then your constitutional pluralism approach that you mentioned in the end? So if the courts feel that they're actually becoming stronger, do you think they have an incentive to then really, you know, move away from the primacy language that has been predominant in their jurisprudence so far? Thank you.
Well, let me remember everything I have to answer to. Now, are we idealists with the what we call in legal philosophy as constitutional pluralism? To be absolutely honest with you, and that comes from my own academic work in international law and state continuity concept, which is a very controversial concept, as you know. So for last 20 years, I think, I've been reflecting and have arrived at this idea that constitutional pluralism is the only way of thinking that we could move forward in the world of, in fact, already in a plural world, because we have so many actors that are important, and we have to take their sort of views into consideration. And it's everything. It's the question of democracy in international law. It's a question of also building a new concept of legitimacy. So I see that, and I do consider that national legal orders are extremely important in international law, the way I call it, global legal order. So if we accept that all of this part is part of bigger whole, then constitutional pluralism is the only way forward. Sort of these divisions that we have lived in so far in theory and in practice, what we are seeing now in Europe, that the divisions have started blocking us, sort of generating or further working on the idea of sort of the common values and shared principles. No, I agree with you. Not everyone, of course, belongs to this particular school of thought. And I'm sure if we made a test right now, we would have probably the whole lot of legal theories that we know about in the audience present here. But yes, I believe. I don't think it's idealistic. And I think it's the only way forward, not only in Europe, but worldwide. And one simply has to, actually discuss it exactly the same way we are discussing it now today. That's the way forward. And I mean, I'm very happy to make an argument about mutual respect. I'm very happy, and in fact, that there are ideas in sort of my constitutional court that the Luxembourg court might like to know about and maybe sort of profit and get an inspiration, not only the German constitutional court. So I think that's just imperative because, you can't continue with this. There are some more important actors and less important actors or periphery at all. We see where it has led. The world has lived with these concepts for years, hundreds of years, and it's been sort of very difficult in terms of progressing towards, indeed, the world based on rule of law rather than anything else. So no, I'm not. I don't think it's idealistic. It's the reality that dictates this approach. So as I said, coming into the courts. Yes, we should maintain that it's no longer about guarding one's competence, jealously against the other actor's competence jealously. That's the discourse we should promote. We're all in it together. So we continue promoting that approach. Whether constitutional identity could be abused, well, I mean, the life shows everything can be abused. So yes. Now, as far as sort of the current composition of the Latvian Constitutional Court is concerned, it is one of the strongest sort of compositions in the history of the court, and I don't see it happening in the Latvian context. And also that there are various factors that sort of, speak against it actually. But I would need to make another lecture on those factors, which I should spare you from. You can come with the complaint to the Constitutional Court in Latvia, because, for example, we have a competence to adjudicate complaints, constitutional complaints from the individuals about the violation of their human rights. And I can easily see a constitutional complaint that brings up the issue of a core of the Constitution. I can easily see that, so that would not be. Or where the Constitutional Court, by adjudicating the case, would consider it necessary to mention that actually this issue lies with the core of the Constitution. Not so long ago we had a question about Latvian language, yet again, where in passing, but we had to point out that the Latvian language forms the core of the Constitution. But that was the case more against it. So, yes, you can definitely claim a violation of a constitutional identity as part of your human rights complaint, for sure. Now, your last, the third part of your comments was a longer one, but basically to sum it up, it looks to me that what you were describing are different. In a way, nothing has changed. You have these good moments and bad moments. If you take the constitutional pluralism approach, you know, some of the practices you would say, yes, this is good. You know, there is an inspiration, there has been a dialogue. This is good, this advances us all. You know, and then there are moments which clearly are isolationist or whichever way you call it. I think it belongs to the current reality. I believe that we know it more or less. Maybe the way I conceptualize it as this old concept of sovereignty dragging along and preventing us from the real issues, maybe that does not come up very often, either in the judicial debate or in doctrinal debate. That I can accept. But I think it's time that maybe we call things the way, sort of what drags us or keeps us back, we should call it. Or we should definitely understand what it is and look for the ways forward. So that's where we are. And this third part of your comment sort of links back to the first question in a way, you know, is it how sort of realistic it is that we all start speaking the language, quote and unquote, of constitutional pluralism. I think it's possible. But I'm an optimist by nature, so.
Thank you very much. I would like to give the words to somebody who is certainly very happy about the content of what you said. Jörg Nolte, please.
Thank you very much, Matthias. In fact, I'm particularly happy that Ineta Zimele is here with us, and it's a personal joy for me to see her and to listen to her. I have a very academic and theoretical question, which may be easy to answer, which may be difficult to answer, I don't know, but that's the reason why I ask. Fortunately, the re-establishment of sovereignty of Latvia happened in a peaceful way. And the Soviet Union dissolved without use of arms, and the Soviet troops retreated. And Latvia could develop a doctrine of constitutional identity and on constitutional continuity under these circumstances. But you used the example of Bosnia, and I hope that is not a frivolous question, but I would like to know, how do you think Latvian constitutional doctrine would have evolved if Latvia would have been in the situation of Bosnia, of a country whose constitution was imposed, or half imposed? Is that an easy question in the sense, well, it's an imposed constitution, this imposed constitution has an identity, and now the Constitutional Court protects the identity of this imposed constitution, and that was just a birth defect, and we don't think about it when applying it? Or is there perhaps a deeper constitution, the original constitution of 1918, upon which the imposed constitution was superimposed and which would have re-emerged in a sense? For example, in a situation where a language issue would come up. Let's imagine Russian-speaking minority would assert a certain right from the imposed constitution, but the submerged constitution would say, but there is a constitutional identity from another dimension. Now, is that just absurd thinking by an academic? Or do you think that kind of issue might arise, and tell us something about constitutional identity? Thank you.
Okay, I pass you the absurd questions of my faculty colleague.
No, it is extremely important to reflect exactly the way Georg reflected. That brings me back to our times at Heidelberg when we had lunches together, and that was exactly the kind of absurd debate that we used to have. It's good to have you in the room. Now, as for Bosnia-Herzegovina, let me start from the scenario where you have the constitution, quote unquote, imposed, because one thing is clear, that it was drafted finally with the agreement of the three constituent people, that it is only with this type of constitutional setting that they will stop exterminating each other, basically. So whether you would consider that imposed, I mean, there is certain legitimacy in accepting this three-community approach, because that certainly, they said, yes, we are ready to go and, stop and start working on. So whether that was totally imposed from above, that is, it's controversial. You can really discuss that. So Bosnia-Herzegovina may not be a good example in this academic question, but the question is valid. When you have a constitutional setting that is imposed from above, that does not come from the sovereign, from the people. I mean, evidently in constitutional law, it's illegitimate. It's basically unconstitutional, plain and simple. But there is another turn I would like to add to this. Sort of, indeed, working, as you know, on state continuity for many decades, what I have come to realize is that we definitely want to avoid what we call failed states. And if you look around where the processes of nation building are difficult and don't sort of work, one thing that I have noticed is, because I have looked at, that nation still sort of separated, yeah, that nation still separated. And I've looked whether these bits and pieces accept the constitutional framework, right? And so the main principles, namely those principles that form the core of the identity. And the more there is an acceptance of the people of that core identity, the stronger the nation-building process, and eventually the stronger the state is. So I think probably that accepts your answers to some extent your reflection, because whether it's imposed or some other, if there is no connection between the people and what the core of that setting is, it will hardly work. And then, of course, into this, you may sort of put in whether the Bosnia-Herzegovina sort of case or other cases. The reason I'm saying that, because in my practice, I mean, the Latvian approach or choice of state continuity, it has received in international organizations sort of different reactions, of course. And not only that, we have followed the international law discourse, where there are many of our friends who argue state continuity is really, what is it? It doesn't exist. All we need is state succession, And I disagree on that point fundamentally, because I link it to the wish of the people. And because Latvia had the possibility, as you rightly said, had the chance to choose this fundamental approach in its constitution, that, I think, largely explains the success of my country, because that people legitimize that I mean, the whole history, we're not going to discuss that. But there is certainly a wish and a legitimacy for the principle of state continuity. And that is important to also accept in international law and in international organizations. So constitutional and international are extremely closely linked and sort of spill over.
Thank you. Further questions from the audience? Yes, please, Ul.
Thank you very much. I was quite intrigued to learn that your constitution requires an advancement of democracy in order for your country to accede to international organizations. That, of course, provokes the question of if and how you define democracy, and secondly, where do you draw the line? I mean, there's plenty of international institutions that also Latvia is a member of, where I could hardly believe any connection to democracy, but still quite a momentum of infringing sovereignty in setting standards technically or whatever, or thinking of NATO, for example. So how is this treated in your country and in your court?
Thank you very much. That is a very current question in Latvia, I should say. Yes, it is true that the Constitution, as you saw, after we became the members of the United Nations, after we became the members of the Council of Europe, but that's easier, provided for this criteria in order to join international institutions. Now, so far, the only case we've got that addresses this is the Lisbon Treaty case of 2008. But I have been trying myself to reflect on this issue, writing commentary, among other things, on Article 68 and really struggling with it, precisely because of this question. Now, the way I sort of see it is the Latvian Parliament and the Constitutional Court in the end would have a difficulty, for example, with the kind of Security Council resolutions, like the Cardi case, that would conflict with human rights. So we would most likely have the Cardi type approach in the Constitutional Court. Because of course, what article clearly said is that we are parties to the such institutions that strengthen our democracy, sort of by extension, the respect for human rights. And we in Latvia really ask for high standard of respect for human rights. So we would have certain difficulties, and we would be clearly sort of encouraging the foreign ministry to follow the NADA judgment of the European Court of Human Rights, or Aldolimi judgment of the European Court of Human Rights, that the Foreign Office should watch out what the Security Council is doing in terms of resolutions and the lists of frozen bank accounts and similar issues. So that's how I, for the moment, see it. And I think probably you also meant the UN Security Council. Sort of,
as an example, yes.
Yeah, as an example. So, but again, that would be our approach in view of the constitutional requirement. But the bigger question remains, in the world of global legal order, you know, is this the way to proceed? Because it's rather confrontational, as was Cardi, for example, and the European Court of Human Rights has always been trying to avoid rather sort of confrontational approaches. Mm.
Thank you.
Thank you very much. As a criminal lawyer, I'm interested whether the approach to state continuity is applicable, for example, on the level of criminal law. That means, for example, that the criminal code of, I think, 1935 is still the criminal code, or is the Soviet criminal code in between the real criminal code in Latvia over the years. Today perhaps they've made a new, but what was the answer of the Constitutional Court to this?
Yes, in the early 90s, it actually applied to all of the areas of law. And what we did, in fact, we looked at the pre-occupation laws and sort of we assessed whether they can be re-affected for sure. The presumption was re-affection, but it's a rebuttable presumption because it was simply the institutions have developed so much sort of within the area of law that it was impossible. Mind you that you know, in 1934 we had a coup d'etat in Latvia and the parliament was abolished. And so luckily the constitution did not suffer, which really saved us because in Lithuania and Estonia that was a problem. And so they could re-affect, they re-affected for a very short time the main principles, and then they both worked quickly on the new constitutions that were adopted in 1992. So we did the following. So we were very careful with whatever had happened in the period of authoritarian regime, because that was clearly incompatible with the principle of democracy in the constitution. But we could re-affect 1937 civil law, and it still works very well. As far as criminal law was concerned, that actually did not work out. And you know better that the area than me. It turns out that somehow, sort of also in terms of the penal policy and all of that, that is particularly complicated, yeah. But the presumption was, yes, we systematically went through all of the pre-occupation laws, and we actually went through all of the pre-occupation international treaties and conventions, and we tried to see whether which are in force, for example, internationally, which need to be renegotiated, re-affected. It was an incredible time in the 90s.
You were talking about a dialogue you would like to reinforce on the European level, as I understood. Where do you think, on which levels we have to fight for maybe this kind of dialogue? You also mentioned on the civil level, and where's your dialogue levels? I would like to. All levels. I mean, I mentioned specifically to you because that's something that I know, the dialogue among the courts, which I think in our sort of European cultural space is central because of our judicialized societies and our particular liking for courts, I believe, in Europe. So that dialogue is crucial, but then of course, I mean, it doesn't help if the courts sort of reach a certain constructive modus vivendi. That also has to spill over to the decision makers and the political leaders. But most importantly, you know, today I had Professor Ewer's students, and we discussed a similar question. And I asked the question, because I know my children, I have 2 small children. I know what curricula they have in Latvia. And I asked the question, are the children, for example, in Germany, as part of European history, learning also the history of the Baltic states? I think we really have a serious work to do on the curricula in all our schools. And that's where I would start.
Bitte? Wo ist die? Okay. I was given the sign that we had time for one more question, but you want to intervene? No. Thank you. I was indicated that there was time for one more question, but I cannot see. Oh, Frau Sting, please.
Thank you very much for your lecture. I just wanted to ask you a little bit about your opinion on the other side of constitutional identity, which is constitutional identification, and what constitutional courts could maybe contribute to enhance a constitutional identification, because that is, in my opinion, also the fundamental issue that we need to address. Only if the people of a state identify themselves with their constitution, it can be the constitution of the state, because otherwise it loses legitimacy. And there is also a school of thought that says that in the absence of any glorious past, as in Germany, the constitutional identification is particularly strong. People in Germany identify themselves with the constitution, they identify themselves with the constitutional court, because there's not a nice history to identify ourselves with. So how could we maybe achieve that in a world of constitutional pluralism, but also within the European Union, to have, maybe in the absence of a truly common history in the European Union, to have people identify themselves with the EU treaties and the human rights protection that is enshrined in the treaties that act as the constitution of the European Union. Thank you.
Okay, I can have another lecture. It's a fantastic question, because that is really a crux of the matter for the future of our democracies, I would say, and at least Europe as the democratic space. I think the time when we could just take things for granted, well, the children will learn something at school, or the society will get it from the media, you know, or our parents, for example, because they lived through processes, that's why they knew the processes. That time has passed. That time has clearly passed, and I see that in Latvia for different reasons. We've never had that time, so to say. So we have other challenges, but the end is the same. It's this democracy and rule of law project, if I may call it that way, that requires that each one of us contributes to it, wherever we are, as professors, as the judges of the Constitutional Court, of the European Court. You see, it's interesting that for the courts, for example, it's very difficult, because if you recall the culture, judicial culture of the 20th century, that was, I mean, the principle was very clear. You only spoke through the judgments. Who was reading the judgments? The scholars, the practicing lawyers, the society. It didn't come to the news. We cannot do that anymore. 21st century requires from European courts, from national courts, well, politicians get into the news anyway, but from everyone sort of with a constructive position, in fact. Those need to reach out on their own initiative to different segments of the society. That's the kind of a downside of plurality, of the plural world we live in, because there is so much competition now, social media, just to start with, right? So in order to get through with the kind of message that you are talking about, which is imperative for our future, you really have to be very inventive and capable and willing to reach out. Now, the Latvian Constitutional Court has the whole communication strategy. We are actually, well, we're doing so many things that would not have enough time to talk about, but we have several audiences, and the first one are school children. School children, we just had a wonderful, if you would see the Constitutional Court, is all in drawings from children of the 6th grade. And the children were drawing, as they do, on the theme, me and my Constitution. And you cannot imagine what they came up with. I mean, I could not do that. You know, so if there is any judge of the court, constitutional or otherwise, that is an idea. Organize a nationwide sort of competition of the best drawing on this theme, Constitution, human rights, constitutional values. So you simply have to do that in the 21st century, and everyone has to do that.
Thank you very much. Thank you very much for this final suggestion. Don't know. Children's drawings about constitutional courts, that's an interesting new proposal. So I finally, and I should stand up for that, but go out of the beamer. I finally have the very pleasant task to thank you all, to thank our partners from the project Wir sind Europa, which is a partnership of several institutions, the Internationale Journalistenprogramm and the Stiftung Zukunft Berlin, founded by the Stiftung Mercator, who is only not present today because they're hit by a wave of influenza. So all representatives were unable to come due to illness. And I thank all the faithful visitors to our Humboldt lectures on Europe. And I would like to have a pre-final applause to Frau Sting, who organized this all with such meticulous work, and I want to thank her by this. So you will have the opportunity to show your particular faith to our speeches next week, because you may be faithful and come and may not be able to enter the room due to the size of the delegation of the Italian Prime Minister, who will give his Humboldt lecture next week. Now, as an explanation, the dates are made by those whom we invite. And we had a few lectures, if not one, after Emmanuel Macron's lecture in January, and now, last year, and now 3 of our distinguished speakers chose to come within 3 weeks. So that's life of organizing the Humboldt lectures on Europe, and I hope you won't be disencouraged when there's a lack of space because of all these security precautions. Now the very last thank I have to give, of course, and I'm pleased to give, and I'm grateful that Frau Sting helps me in that, is to our speaker Injeta Ziemele, for her most inspiring speech upon the Latvian position of constitutional law, and we like to materialize it. Now, you do not know what everybody in the room knows what is in there. You know that? You know the place? No? I have to keep the microphone. You gave me the Latvian constitution for our library this afternoon. No, there's no law in there. Everybody in the room knows it. But I show you one, the Berlin Bear, in chocolate, and I hope you will enjoy it. Thank you so much for your speech. Danke schön.